This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on the dynamic trends shaping the legal world. Learn more at pli.edu/ftpod.
Welcome to Fast Tracked, Emergent Issues in the Legal Profession, brought to you by the Practicing Law Institute. I'm your host, Jen Leonard, founder of Creative Lawyers. Buckle up as we hit the gas and explore the most dynamic trends shaping the legal world. I hope you'll join us as we explore the future of law today. Welcome back, everybody, to the Fast Tracked podcast, a production of Practicing Law Institute. I am your host, Jen Leonard, founder of Creative Lawyers. And on this podcast, we explore all of the really interesting and swirling dynamics that are driving change in the legal profession. And we are delighted today to be joined by Stacy Guillon. Stacy is an arbitrator and mediator with Decisioncraft, and she also has a background as a litigator. And we are going to explore today how generative AI, which we've all been buzzing about for a couple of years now in the law firm space, in the court space, in the law school space, but how will it impact alternative dispute resolution? So welcome to the podcast, Stacy.
Thank you so much for having me, Jen. I really appreciate it.
I'm delighted. And I have to start with a question that has absolutely nothing to do with AI, absolutely nothing to do, I think, with alternative dispute resolution, though I'm a city girl, so you can tell me if I'm wrong. But we learned, and I'm going to give a hat tip to Daniel Pinetz on PLI's production team for pointing this out, that you are actually originally from a sheep and cattle ranch, and you serve as the president of the board of the Colorado Cattlemen's Agricultural Land Trust and a trustee of the National Western Stock Show. And I haven't fact-checked this, but I'm going to go out on a limb and say you're the first guest that has active engagement with the cattle community.
That's probably true. They say less than 1% of Americans is involved in agriculture in any way. And that includes, sort of tangential things like forestry. So odds are in your favor on this one, Jen.
Oh my gosh. Tell me a little bit more about what this even involves.
Sure. So my grandfather and then my dad ran a sheep and cattle ranch in northwestern Colorado collectively for almost 100 years. So that was a big part of how I grew up. It was really, seminal for me and formative. And then when I started practicing law, I became very interested in helping the agricultural community. So I did a lot of litigation on behalf of farmers and ranchers before then becoming a neutral. And now most of my agricultural work is in extracurricular activities, if you will, like boards. And of course, I still maintain a close personal tie to that community and love of the industry.
That is so cool. When I come out to visit you in Colorado, you're going to have to show me around and give me the literal lay of the land when it comes to cattle.
You got it. And, Colorado in so many wonderful ways still has a lot of ties to agriculture. So it's sort of everywhere you look. It'll be easy to do that wherever you are in Colorado, Jen.
Awesome. And, I love innovation. I know you love innovation. One of the things I love about innovation and creativity is taking experiences that are wholly unrelated to the work that we do and finding ways to sort of adapt them or inspire new approaches in the work that we do. Have you used any skills or mindsets that you developed in your work in that arena as a lawyer?
All the time. I think any job sort of that relates to nature, any work that you're doing with nature gives you unbiased feedback, right? Unlike with some jobs, you cannot manipulate natural feedback. You're good or you're bad, you're right or you're wrong. And I think that's a really helpful skill set to have, to remember that you really have to strive to do your best because sometimes it's not subjective.
I love that. I feel like there's a workshop on mentorship and feedback in there somewhere. Maybe we could develop it in the future. But could you tell us a little bit about, we talked at the beginning, I also have a background as a litigator, but no background in alternative dispute resolution. So I'm curious what the story is like when you transition from litigation to working as a neutral. Tell us about that.
Sure. In a certain way, I think I've always been a neutral at heart. I was a law clerk, and clerking really clicked for me. I liked sort of coming to cases from that approach. And then in my years as a commercial litigator, I always saw both sides of the case. And in particular, everybody loves going to court as a litigator. That's absolutely true. But I also really loved arbitration because of the opportunity for some creativity in the process. It wasn't this sort of one size fits all. So when I had this opportunity to co-found Decisioncraft, which is an ADR boutique with a former Colorado Supreme Court justice and the very well-respected senior partner at the law firm where I'd been practicing, that was just too good to pass up.
That's amazing. And I'm sure you've developed a lot of entrepreneurial skills as a problem solver, as a neutral, but also as somebody building something from scratch, right?
Oh, absolutely. It's a different kind of a model. A lot of the neutrals that I worked with in my litigation practice were at JAG or they were at JAMS. There were a few sort of solos, but this sort of small ADR boutique is not something with which I had a lot of contact. Nor, of course, did I have a lot of contact with younger neutrals. Most people transition to becoming full-time neutrals in their 60s or their 70s, and I am not in my 60s or my 70s. But there are some significant advantages of that, including because it gives me a unique take on our subject today, how technology is presenting opportunities to transform ADR.
I love that. And it's the perfect segue to talk about AI and technology generally. And, I was just talking with somebody earlier today about the structural challenges that law firms face, even recognizing the change that's upon them. And it's really cool to be working in something that's brand new and thinking about what the future of your work might look like in the work of neutrals and those engaged in the ADR process. So could you talk a little bit about what you see as the future of AI and ADR?
Yeah, absolutely. I think it is transformative in so many ways. So there's a part of me that doesn't know where to start. When I have this conversation with my colleagues, of course, the first question I get is, are there going to be, automated arbitrators? Are we going to have AI arbitrators? And I think the answer is yes. Identifying contexts in which that's desirable or ethical deserves a lot of thought. And I really hope that those people who hold their AI models out as performing that service are doing it ethically in an informed and methodical way. But, in the short and medium terms, it means that we as neutrals are sort of on notice that this form of competition is coming. And that means we really have to up our games and demonstrate to the marketplace that we add value that computers can't. And so that's really the lens through which I think about what's coming. And what that means is that we as humans have to try to figure out how to leverage the increased efficiency that AI can offer us in our practice, while also being more thoughtful about what that human touch is that we bring. Why is the human contribution important in arbitrations and mediations? And how do we solidify those concepts? Because for right now, I think people they have an intuition that that's the case, maybe, but they aren't necessarily able to quantify that. And given the cost difference between a machine arbitrator and a human arbitrator, it's really incumbent on us to get serious about talking about and doing more than talking about what that looks like.
It's funny you say that, because the point that you're making about the human element, emerging as the most important part of the value that we bring, and the AI will help with the things that humans don't add value to, has become such a common refrain among many people, including myself, because I believe it deeply. But when we dig into it, it's sort of like, well, what does that even mean? Because everything we do now, even if we're automating it, is human focused. So I have one question, and then I want to ask a second related question. But do you have an early sense or instinct about what some of those human skills that will never be replaced by AI, or not in the near future anyway, might be?
Yeah, I'm sure that I'll listen to this even several years from now and think, oh, that was terribly wrong. But for the moment, I think I have an idea. And some of it is, I think people who aren't very familiar with AI assume it's not very creative. Then you start using it and realize it absolutely is. So I don't know that it's there. However, empathy is a really important part of binding decision making. And though in my experience, AI is pretty good at sort of emulating empathy it isn't really taking the full picture into consideration in the same way that a human would. Having that nuanced understanding of what might have caused somebody to take a particular action and whether those potential causes are reasonable and whether there were some disadvantages at play. While the AI, I think, superficially can highlight those, integrating them into the decision, I think at least so far, is pretty uniquely human and also pretty central to the concept of fairness and due process.
So human empathy and really sort of like, it sounds like that nuanced understanding of how the different elements of a situation combine in ways that maybe would escape an AI for now.
Yep, that's exactly right. I mean, at the end of the day, in a lot of ways, arbitration and to a certain extent mediation are about judging human behavior. And in that respect, some humanity is central. Whether the AI will be able to mimic that, I haven't seen that yet. But that's where I think we really need to hold on to the human element of binding decision making.
So, and don't feel badly if these predictions don't pan out. I still remember sitting on the couch with my brother like 20 years ago when the first flip phone had a camera. And we both were like, what a stupid idea to have a camera in a phone. Why would anybody ever use that? Which is why I'm not sitting on a Caribbean island somewhere with a drink in my hand.
Yep.
But I also want to ask a related question about the idea that we're sort of talking about these things that we assume will be the future, and forward-thinking people like you and others are trying to get ahead of that as much as possible, right? But there's this other challenge that's unfolding at the same time, which is, okay, you're locked and loaded and you have decided you're going to focus on the future and see where the puck is headed. But other people are just sort of emerging into the conversation, and other people are resistant to the conversation at all. And so it feels like, in addition to identifying the way that we add human value to the collaboration, there's this whole sort of profession-wide literacy campaign that we need to execute. And it's really hard to do both of those things at the same time. But I don't see it frequently in your landscape. So tell me a little bit about what the AI literacy, change management, upskilling, reskilling world looks like in the land of alternative dispute resolution at the moment.
Well, you're absolutely right that I don't think conversations about AI are as prolific within ADR as they are in other places in the legal industry. Now, granted, I should sort of divide that a little bit. Law firms are absolutely talking about this to varying extents, which nobody knows better than you, Jen. And as they talk about AI in litigation, they are essentially talking about using AI as advocates in arbitration. There aren't a whole lot of differences there. However, from the neutral perspective, there isn't a whole lot of dialogue about AI, with one major exception. And this exception will be familiar to you, Jen, because this exception comes in the form of your 2030 Vision co-host, Bridget McCormick, who is the current president and CEO of the American Arbitration Association, which many of your listeners will know is a leading arbitral institution. Bridget is very much on the forefront of AI and how it affects access to justice in the courts, but also in arbitration. And so she is very much leading the charge and causing these conversations to happen at the high level. How that trickles down to whether there are incentives for arbitrators to actually use AI in their arbitrations is, that's, I think, the next step.
Yeah. And for those listening, if you're interested in hearing firsthand from Bridget and Dean Andy Perlman of Suffolk Law School about how AI can impact the public interest, I encourage you to go back to season 1 of Fast Tracked and listen to the great conversation we had with them. And absolutely, Stacy, I feel like, all of the things that you would read about in Harvard Business Review every single month are required for AI transformation, including leadership. And understanding how to create a vision and have other people inspired by it and have impact. And then sort of zooming in to the really narrow application. I can imagine people listening to us and saying, yeah, this all sounds great. It all sounds very promising, but also very theoretical. So maybe for the listeners, it would be helpful to hear from you some narrow use cases that you've either experimented with or heard others using in the ADR context a little bit more?
Sure. So let me sort of, for this purpose, break up arbitration and mediation because the ways in which I use AI are pretty different, and we can talk about why that is. But in arbitration, I think the lowest hanging fruit is really in document analysis. Arbitrators, especially arbitrators in complex cases, get a lot of documents, and mastering them is a really important part of excellence. AI, as some people know, but if you don't, this is a great point of entry, can summarize documents. It can create timelines, which arbitrators have historically done, painstakingly by hand with hours and hours of time. AI can identify where in a large set of documents we can find a particular piece of information, which I use during prep and also during actual arbitration hearings, or often when I'm drafting my award. AI can excerpt text across a huge document set that's relevant to a given issue, and then it can refer us back to the primary source so we can go ahead and read it for ourselves. We don't have to rely on AI for the synthesis, but at the end, it really gives us a better understanding of the substance in less time, which means less expense for the parties. To put a really fine point on it, I'll give you an example. Just last week, I was writing an award, and I asked AI, where in the record can I find this particular fact? AI found it, referred me to the primary text for quality control. I read the primary text, and then AI even auto-generated the record site that I put in my draft award. So that I think is the point of entry for arbitrators. In mediation, I think AI can allow mediators to do much higher quality prep in a lot of different ways. As a litigator, I was always really conscious of the reality that the first several hours of most mediation sessions were spent educating the mediator. While a bunch of lawyers and their clients sit around and run the clock, and that was frustrating for me. But the reality is that most mediators only have a few hours to spend with the materials in advance. Granted, my frustration with that is what led to my firm's commitment to doing sort of deep dive prep for mediation. So that's not universally true, but the deep dive is not always an option for every mediator in every case. And whether you're doing just a few hours of prep or whether you're doing a whole bunch of prep, AI makes that prep time much more valuable. It, for example, can critique expert reports. It can instantly write legal research memos. Or I used this before, it can turn a document into a podcast that then the mediator, like me, listens to as they drive into work, where I'm converting time that I wouldn't have been able to use for prep. Granted, I use that for non-billable prep, but for prep, and was able to use that for the benefit of the parties. So that's really, I think, the entry point for mediators using AI.
Isn't the podcast creation the coolest thing?
So much fun.
I have a friend who's a lawyer in a corporate law department who does the same thing you do. It's like found time to be able to convert a lengthy public document into a podcast and listen to it in the car or on transit. I love that. But as you're talking, and I have this experience working with AI, I know other people do. When I describe how I'm using it, it becomes pretty clear that I'm using it in a way that I would use a whole team of junior people around me if I had a team of junior people at my disposal. And we talk about it a ton in the law firm context about what it means for junior associates. But what does it mean for the future of leadership in alternative dispute resolution?
For better or for worse, most mediators and arbitrators don't have access to those junior people. Judges have law clerks. Arbitrators don't. Most mediators outside of law firms don't have law firm associates to assist, and some of those within law firms really don't use their associates on their mediations in the same way they would in their litigation. So I actually think that creates a real opportunity in the context of ADR, because this is all found value. We're not displacing anybody by using AI for these tasks. These people aren't here. There aren't junior people in this industry in the same way. And that has historically been, I think, a disadvantage, though a deeply, deeply ingrained one. But it means that there's less friction as we make this transition in ADR as compared to in law firms, where they're trying to sort of refocus that junior level of their employee base.
Right. That's right. So they're trying to solve for the business model problem overall, but this is a value add here. And I imagine because so many neutrals come from the judiciary that and correct me if I'm wrong on that point, but as judges start to use AI with their clerks and see its benefits there and get a little bit of support from their clerks in learning how to use it, that those benefits will redound when they enter alternative dispute resolution as neutrals. Is that accurate, do you think?
I hope that's true. Most neutrals are, yes, either former judges or they are senior litigators. But, in my experience so far, it seems like the clerks or the junior associates are using the AI for the most part, rather than having the judges or those senior litigators be hands-on. So I don't know, if that continues to happen, eventually these junior people who use AI will rise through the ranks, but it won't happen in short order. I think we have sort of more work to do. For those of us who believe that this can really be a benefit to the parties in ADR, I think we're going to have to do the heavy lifting of inspiring people who don't naturally have experience with these tools to figure out how to use them.
So I want to ask you one more question that's a fine point on this topic of narrow use cases before we move into ethics, because I know you have so many great thoughts about the ethical implications of using AI here. But you and I met one another at an event, and a neutral approached me and, was really, really interested in using AI, but didn't have access to any tools that are proprietary that would protect information, and asked me, how can I use ChatGPT or Google Gemini or what's out there that I can use? So do you have any guidance for people who don't yet have access to enterprise-wide tools on how they can just start playing with AI to get used to it in ways that are safe?
Yeah, absolutely, I do. And, in arbitration, the concerns about confidentiality are significant and warranted. And we as arbitrators need to be really careful with the confidentiality of the case information. There are also some other constraints that we can talk about in the context of arbitration. In mediation, I think is where neutrals have the opportunity to play with this for a few reasons. One is that a lot of the documents that we receive in mediations have been publicly filed. So at least from my perspective, I have less reservations about then using just sort of a general purpose tool like ChatGPT. By the way, for your listeners who are not familiar with AI, they should pay for ChatGPT. When you say, oh, I played with the free version of ChatGPT and I wasn't impressed. Okay, that doesn't mean very much to me. In order to get the full value, you got to pay. It's not very much a month. It's
Thank you so much for saying. I now lead every presentation with that. If you walk away with nothing, it's pay the $20 a month for the cutting edge ChatGPT version.
Yes, or go to Claude. There are absolutely ways for little to no money that you can access some of the benefits of these tools. And like I say, I would start in mediations. I disclose in my mediations that I use AI sort of generally, and I haven't had pushback with that. I'm very thoughtful about confidential information, absolutely. But if all I had were a paid ChatGPT or Claude, I would feel comfortable at least getting started by having the AI do some analysis with those publicly filed documents, because they're already out there. They're already on Pacer, or they're on your state court's filing system. And maybe if there's some, dispute as to whether those files should have been sealed, don't start with that case. But you get my point. There's absolutely materials coming to mediators that are suitable for this use, and they can do that analysis on a case-by-case basis. But I think there's an opportunity there for neutrals to really sort of get familiar with AI's capacity before they're really approaching some of these harder ethical issues that arise, particularly in arbitration.
That's great advice. And I wonder, if those are the safe use cases for AI, maybe you could explore some of the major ethical considerations in using AI in an alternative dispute context.
Yes, I'm happy to talk about those. I think those are so important. I want to do so with sort of the disclaimer that I think there's so much conversation about the ethical issues in the context of ADR that it is overpowering the potential of AI to assist ADR, to help make ADR better for the parties. And so I'm so glad that you and Bridget and others are talking so prolifically about all of those. That's really important. But we can't, those ethical issues are absolutely out there. The sort of high level ones, first I'll start with sort of the cardinal rule of arbitration is that an arbitrator cannot delegate decision making, period. One of the benefits of arbitration is that the parties get to be involved in choosing the neutral, which means that the neutral they choose should be the neutral making the decision, not her colleague and not her computer. So that certainly plays, that's delegation of the actual decision making. There are absolutely opportunities well within the confines of that standard to use AI to assist with other things, like some of, the document issues that I mentioned earlier that really aren't decision making related. They're procedural. And then as we escalate, what is decision making? Where is that line? Is going to be a big conversation in this community. Another central concern that we've already talked about is confidentiality, but that's not unique to AI. Arbitrators have been required to do the same kind of analysis of the privacy elements of terms and conditions when we use a whole bunch of other common software like cloud storage. As far as I know, most, if not all, arbitrators are getting confidential case documents by email or storing them in the cloud. So they should be pretty facile with reviewing the terms and conditions to make sure that those documents stay private. Accuracy, of course, is really central here too. This is not unlike litigation. And of course, the Avianca litigation, which the New York lawyer presented those hallucinated cases, has made this issue infamous. But just as advocates are responsible for the accuracy of the information that they present to arbitrators are responsible for the accuracy of the output that they generate too. But that just means double checking. I think about this like I think about a lawyer using the work product of a new associate to their firm. Right? You wouldn't just copy and paste it and use it whole cloth. You would check it and confirm its quality. That doesn't mean that work doesn't have value. It just means that this isn't a one-step process. There are a couple of ethical issues here that don't get the spotlight as often. One is competence. The rules of professional conduct require attorneys to be competent with technology because of the benefit that creates for clients. In my mind, that applies to arbitrators too. Whether the arbitration is governed by the AAA, JAMS, or other rules, it's our duty to make sure that we are providing for just, efficient resolution. And AI can be a game changer on the efficiency side. So proficiency with these tools can benefit the parties. And so that's really important. Like I say, that means proficiency with the risks and limitations too. It's not all sunshine and roses, but to me, the thorniness of this doesn't justify ignoring the tool's potential value. It's a balance. And the last one that I'll address here is disclosure. Disclosure in arbitration in so many respects, potential conflicts, et cetera. The sort of motto is disclose, disclose, disclose. And there are those who say, the same is true for AI. And then there are those in the community who are saying, hey, wait, we've been using AI features of tools like Microsoft Word now for years, and they haven't been in any of our disclosures. I think the argument for disclosure gets stronger as AI contributes more substantively and not just with, sort of typo correction and phrasing and clarity. The Silicon Valley Arbitration and Mediation Center has some thoughtful guidelines on the subject of disclosure, and I would refer to those, but it's really not black and white.
That's really interesting too, because I think of it in all the same ways I think that you do, which is the ethical considerations are real and we need to be thinking about them. And yet I think that the ChatGPT lawyer story did more damage to the discussion profession wide than anything that's happened in the last 2 years, because first of all, there's sort of no body of people I trust more to be deliberate and considerate about rolling out a new technology than the legal profession and judges and neutrals. And like you, I just see so much opportunity to solve problems that have just stymied the profession forever using this technology. And I wanted to go back to the point on competence, because I'm curious, this is a little bit of an unfair question because it's another prediction. But I think it's comment 7 to rule 1.1 sort of suggests that we also have a duty to stay abreast of evolving technologies as lawyers. But if you dig into any cases where lawyers have actually been disciplined over their failure to stay abreast of relevant technologies, it's so egregious. It's like not being able to use word processing or not answering your email for months on end. It feels like to me we sort of need to think a little bit differently about what competence technologically means now. And I wonder if you agree and if you have any thoughts on what shape that should take across the profession in terms of staying abreast of technology.
Yes, I agree 100%. And in arbitration, there's a little bit more aspiration, I suppose, in the duties that we're assigned because of the rules reference to efficiency. If it's our duty to make a case efficient, and that is one of the tenets of arbitration. People come to arbitration because they want it to be faster and less expensive. One of the reasons. Some come for confidentiality, et cetera. But I think they reasonably and they expect it to be faster and more efficient, and efficiencies in the rules. So from my perspective, that makes it incumbent upon arbitrators to figure out how to make themselves as efficient as they can, even if failing to do so would not be punishable, like you say, by the rules of professional conduct. How we do that, I think so much of it is about incentives. Arbitrators, there are a lot of arbitrators out there, and they, very few arbitrators you'll talk to will say they have as many arbitrations as they want to have. I think that creates an opportunity to incentivize them in the same way that law firms can be incentivized. We were talking last time we met, Jen, about the Ford GC's letter to the law firms that work for Ford, requiring that they explain how they're using AI because Ford's in-house counsel were so convinced that AI would benefit them and reduce their cost. Those same opportunities are available in the context of arbitration, and where parties have so much influence over the choice of their arbitrators, they can start asking those questions tomorrow when they select arbitrators, especially in large cases where they're doing that level of due diligence economically anyway. And of course, arbitral institutions have a lot of opportunity here to incentivize increased efficiency and more use of AI by their arbitrators because they have a lot of influence in how arbitrators are selected as well. So if we're really trying to put forward, and we should be, as arbitrators, human arbitrators are competing with just looming probability of machine arbitrators. If we're looking to put forward our most efficient, most effective arbitrators, we really need to be thinking about that more deliberately maybe than ever before in light of these new opportunities and in turn, the new competition that AI presents.
And I love that you came back to machine arbitrators because that's where I was going to go next, because at the very beginning of our chat, you said people ask, will AI replace arbitrators and neutrals? And I assume you also mean judges, lawyers, but we won't go there. But in your realm, you said probably yes. And then we talked about decision-making not being delegable under the rules that govern neutrals. So do you envision a change in the future as to how we think about decision-making? And what areas do you envision as appropriate for the earliest sort of matters to be tested with machine arbitrators?
Frankly, I think arbitration is sort of fertile ground for testing machine decision makers, in part because arbitration is largely a creature of contract. When two parties decide that they want an issue resolved in a certain way, arbitration, within the bounds. And so, I've heard you, Bridget, talk about the fact that when you got in the community, the legal community is saying, no, there will never be, or at least not soon, AI arbitrators. And the business community is saying, we're ready for AI arbitrators tomorrow. If the parties want it, they'll make it happen. So the idea that there aren't going to be AI models that hold themselves out as deciding disputes, even arbitral disputes in a binding fashion, I think that's very unlikely to be the future. I think these will emerge. Their success, of course, is going to depend on a number of factors. I think that we'll start to see them emerge in controversies in disputes that have a fairly low amount of controversy. And from an access to justice perspective, that's really great because it's really difficult to litigate or even arbitrate some of those disputes economically. And then if the AI performs well, I see it expanding into other types of cases. And meanwhile, like we talked about earlier, we as human arbitrators are going to have to rise to the challenge and offer added value and maximize our own efficiency. And if we're able to do that, the market will keep sending us cases. I think likely cases in which the amount of controversy is higher, or there's sort of a lot of human elements. It's not just apply law to facts, which frankly is sort of a bad way, but an accurate way of describing data processing. Applying pre-existing rules to facts is data processing. And so in that respect, there are legal disputes that could be decided by a machine.
Very interesting. And, sort of a relatively new and unprecedented dynamic across the profession of this idea idea. I don't want to frame it as losing control, but having to really think about the market pressures for our services in every role, right?
Yeah. Absolutely. And there are those who think that that's sort of derogatory in the context of arbitration. I really don't. I think of it as sort of inspirational that we need to continue to hold ourselves to the highest standards and evolve and change so that we are meeting the moment. And this is, the epitome of that challenge.
Well, I think that is the perfect note to wrap up our conversation, Stacy, with inspiration and hope and optimism about the future of AI and alternative dispute resolution. Is there anything else that you wanted to share with the audience?
No, just to say, I know that there is AI skepticism out there. I'm so grateful to people like you, Jen, who are talking about this, talking about the opportunities that AI affords. I would say to the neutrals who are listening and to the lawyers who are engaged in selecting neutrals and to the parties who appear before neutrals, those opportunities abound in arbitration and mediation. In certain ways, arbitration and mediations can be laboratories for innovating with AI. And I hope that all of you keep that in mind so that we can continue to inspire and incentivize everybody involved in those processes to level up. We're ready and the technology is there. So now all we have to do is collectively decide that we're going to do it.
I love that. And thank you for, being a beacon to think about in ADR, the opportunities here. It's so fun to see different leaders in the profession light up with the possibilities that this creates. And I want to thank you so much for sharing your perspective with everybody about the opportunities it creates in ADR. So thanks for spending your time with us, Stacy.
Well, thank you, Jen, and thank you to PLI. This has been a pleasure.
And thanks to everybody out there listening. This has been another episode of the Fast Tracked podcast. We look forward to seeing you on our next episode as this very exciting present and future continues to unfold all around us. Until then, be well. I hope you enjoyed this fascinating conversation as much as I did. Visit pli.edu for more insights, education, and resources for navigating this dynamic landscape. And until next time, stay curious and stay adaptable as we work together to chart a course into an exciting future.